is something I know you've been very passionate about. I followed your presentations at The Hague. You still hammer on quality justice. What's the details of that?
Quality justice, in a nutshell, would be characterized by, well, as I mentioned, credibility and effectiveness. But credibility in itself would be fed by how knowledgeable the judge is. You know, that one you would call it competence, how competent the judge is. That's very important. Competent, firstly, there's a basic competent, know your law. Yes, it doesn't, these days we all agree, it doesn't all reside in the bosom of the judge. That's why certainly throughout the Commonwealth, continuing judicial education is harped on all the time. And they go back to the classroom and be taught about trends and what is happening in other jurisdictions and new enactments, complicated enactments. You take them through provision by provision and so on and so forth. So it's competence. It is also independence. Independence is as I say, this is sine qua non. You cannot have justice. The word justice itself is not even just a common word. It's even I would say it's a religious word. It's a biblical word. Yes, it is just. It is as it should be. Yes. So that's why independence and integrity. You cannot be independent and lack integrity. And if you lack integrity, you cannot be independent. So that they go together. And then efficiency. You know, sometimes the delays in the whole thing from the commencement and through on and on and on and on and on and on, that can give an impression that they're up to no good. Or I won, but by that time the money was worth nothing to me, therefore I did not get justice. A litigant can say that. Yes. So efficiency is important. Efficiency is also partly personal to the judge, and to a very large extent also your workspace. How efficient are your? These days it's not your pen anymore. It's your IT, your connectiveness and all that. And that's why things like e-justice and so on become very important. That's why, once again, I come back to training, judicial education, and even also the training of the staff. You can be a highly judicially trained and educated judge, but if your support staff lack in one skill or the other, that can be a problem. So competence is also part of that. Yes, and then it's when you're looking at all those things coming together, that's when public perception is also important, because if you've delivered in an independent and impartial way with integrity, if you've applied all your knowledge to what you're doing, you've applied all the modern technology and all that to arrive at your decision, and it comes to, let's say, execution of the judgment, and nothing happens. The person won, but they might as well have lost, because now it's a big hassle to go to get your land back or your house back, or get the person to pay your money back to you. Then you're blaming the judge. That judge gave me a useless judgment. No, the judge gave you a good judgment. It is the execution that failed you. Yes. And execution of judgments are both part of it, there's the bailiff service, and which also needs, I have to admit, still needs a lot of work to be done, a lot of inputs to be put in there to make them efficient. And then part of the execution, you need the police service to help you do the execution, because it's really an executive act to execute a judgment. And for me, perception and its result on effectiveness is important, primarily because when your outcomes, in other words, as I said, the judge wrote a perfect judgment and gave you a good decision. It's not been appealed against and all that, but you're not getting the fruit of your victory because of execution being, the person is successfully maneuvering you all over the place. See, those are the things that lead to self-help.
Resorting to the use of either land guards to get a land back.
Yes. Yes.
Forms. You talked about the timing, or how long it takes, for instance, for cases to travel all the way to the end before the judgment is even given. How important is timely justice, taking into consideration the saying that, yes, if justice delayed is justice denied, but when justice is hurried as well,
justice is buried. I'm glad you know that second part.
How do you balance it between the two?
You balance it through effective case management. All these are systems and methodologies which are now in place to help right from the lower court all the way. Even the rules of procedure, court procedure are part of case management. If you sue somebody, this is how you do it. And when you have filed it, after this period, within this period, this is what's supposed to happen. After this period, this is what's supposed to happen. Those are all the laid down procedural processes. Many times the procedure is there, but it's not being followed. Maybe the person started the case, and yet the writ has not been served yet. So you're waiting and waiting and waiting. Every time you go to the court, we haven't been able to serve the writ. There are processes whereby if you've tried a certain number of times to serve and it has not been, the service has not taken place, the plaintiff can trigger a certain process for substituted service. That is there. But if you don't trigger it, then I don't know what's happened to your writ, but your writ has not been served, and you're just sitting there and you're lamenting, these court people, they are all thieves. And the magistrate, the thing has not even reached the magistrate yet. And the magistrate is already being insulted. Yes. And so on and so forth. So if people would take an interest in the process, what ought to be, if people knew what ought to be, then they could really be very critical about what is being done. Because I was always sometimes very concerned about how long it will take, let's say, it will take a litigant to take the next step, which they could have taken months ago, because there has been the time lapse, the statutory time lapse, whereby you can apply for default judgment, you can apply for the case to be thrown out, You can apply for this, you can apply for that, and you're just sitting there, and nothing is happening. That is not the process's fault. It's you're not a vigilant. Equity aids the vigilant, not the indolent. Yes. But all things being equal, it is possible for a judge, once the case has landed in that judge's court, to so manage the process that the judge will even be able to tell when hearing will end and when judgment can be delivered. There are some judges at the High Court, for example, who they've perfected their case management systems, because once it's your case, the case is before you. You're the one who you time it, and the lawyers who want to play their tricks, they know the judges to avoid, because they know this adjournment they will not grant it. They will not countenance unnecessary delays. And one judge in particular, she would write out a timetable for the case, and then have it served on all the parties, and they've agreed on this date, on that date. You will take your witnesses, you will do this. And these days there's a witness statement. So every person producing a witness comes up, brings the witness statement, which is sworn. It's like an affidavit. So it's only the cross-examination that's done in court.